Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina, and today's topic is A Never-Ending Issue, the report on the EU Expert Group on Standard Essential Patents. Standard Essential Patents, or SEPs, as the name implies, are patents which are necessary to implement or comply with an industry standard. As a result, jurisdictions around the world require that such patents be licensed under fair, reasonable, and non-discriminatory terms, also known as FRAND licensing. SEPs and the parameters of what constitutes a FRAND license has been the subject of ongoing and seemingly never-ending dispute and debate. Today, we are speaking to one of the contributors of the recently published EU Expert Report on the licensing of SEPs to discuss the current challenges and issues that continue to plague this space. Joining me today is my co-host, Matthew Hall. Hi, Matthew.
Hi, Christina. It's good to be back.
Good to have you. So what are we talking about today?
Well, as you said, we're going to be discussing the January 2021 report of the EU SEPs, or Standard Essential Patents, Expert Group on Licensing and Valuation of SEPs. This is an important area. Licensing and valuation of SEPs is an extremely challenging and difficult area in the EU, UK, US, and elsewhere, as you will be aware.
And who do we have as a guest today?
So we're very pleased to have a member, as you mentioned, of the SEPs Expert Group, Aleksandra Kuznicka-Cholewa. She's a lawyer and senior associate in the IP and TMT group at CMS Cameron McKenna in Warsaw, Poland. She holds a PhD in law and specializes in IP law. Her PhD was titled The Standardization of New Technologies, Its Influence on the Freedom to Exercise Patent Rights. Hello, Aleksandra.
Hello.
Thank you very much for joining us. As Christina said, we're going to be talking about SEPs, and in particular the report of the EU Expert Group on SEPs, which came out in January. Could you just take us through what that report was? Who formed the group? You were one of the 13 members. I've read it. It's 230 pages. I haven't read necessarily every last word, but it's certainly an impressive document. Can you just take us through to start with what it was aimed at and broadly what it covered?
Yes, of course, and thank you for invitation. In its communication back from the year 2017, the European Commission announced that it would monitor the SEP licensing markets with a particular focus on IoT technologies and would set up an expert group with the view to deepening expertise on industry licensing practices. As a result of this communication, the expert group has been set up by a Commission decision in July 2018. The main task of the expert group was to provide the Commission with economic and legal expertise and to assist the Commission to inform policy measures that it may take to ensure a balanced framework for smooth and efficient licensing of SEPs. We were also invited to generate ideas looking forward into the future framework of SEP licensing and valuation. These ideas should fit into the future debate on SEPs alongside other studies and analysis. On this basis, we have formulated findings and proposals. In the report that has been recently published that you have mentioned, we have analyzed how SEP licensing is evolving and the use of SEP-based standards, notably in the IoT. We have identified key challenges, analyzed current ways of dealing with them, and made a number of proposals called structural reforms that may be considered to achieve the suggested way forward. Overall, we have generated more than 70 proposals, which are in details described in the report. The main topics addressed in the report are, among others, how to increase transparency about SEPs and SEP licensing, where to license in the value chain, how to establish fair, reasonably, and non-discriminatory terms and conditions, or how to facilitate negotiations and dispute handling.
Well, thanks for that introduction. I think we'll get into some of those topics in a minute. But this wasn't a European Commission report. It was, you were given complete freedom, were you, as I understand it, to look at what you wanted to look at, and the Commission was really just facilitating it. Is that how it worked?
Yes, exactly. So the views that are included in the report should not be treated as European Commission's views. Those are just input from the market, from the experts working day to day with licensing and valuation of standard essential patents, in order to stimulate further discussion among relevant stakeholders and facilitate the Commission further debate and provide directions in which some further reforms may be taken in the future.
And did you? We said there were 13 members, presumably coming from different areas. Some may be more used to working for the licensors or the implementers. Did you all agree, or were there lots of? Presumably you didn't agree. Were there lots of differing views and you couldn't really come to an agreement on many points?
So maybe first point of clarification. Of course, we are coming from different industries, and we had different backgrounds. But we were appointed as an independent experts, acting in our personal capacity. So we are not representing views of SEP holders, neither SEP implementers, but we were there to provide objectives, views, and expertise for the Commission. Of course, as you can imagine, the subject of SEPs licensing and valuation is highly controversial. So, of course, there were many discussions, and I think it is well reflected in the report, because the report contains many proposals, and there were no agreement with respect to, not all members agreed to all proposals, but the aim of this report is to provide different ways on how to move forward.
Okay, great. As you said, there are over 70 proposals. Let's look at some of them. Then let's move on to look at transparency. You mentioned that. I know it's an important issue that was mentioned or discussed in the report. What was it looking at, and what did the report really at a high level comment on in relation to transparency and SEP licensing?
Of course, it is a highly important subject. As the members of the expert group, we have generally agreed that providing greater transparency on the SEP landscape could be beneficial to both SEP holders and SEP implementers, as it may facilitate smoother SEP licensing negotiations and reduce SEP litigation, paving the way for more efficient advancement in technology markets. Such a need has also been indicated in the European Commission IP Action Plan that has been published in November 2020. Currently, there is a lack of sufficient transparency as to the ownership and number of true SEPs covering an adopted standard, which makes it difficult for implementers to determine what SEP licenses they need for their standard compliant products or services. It may become even more problematic in the rollout of the Internet of Things. The transparency of the SEP landscape is expected to be of particular importance in the current market environment, in view of the fact, first of all, that a cumulative number of declared SEPs continues to increase. After several years of stabilization, the recent development of the 5G cellular standard is resulting in increased number of declarations and declaring companies. Moreover, number and share of true SEPs, so the SEPs that are in fact essential, are subject to different estimates. It is generally agreed that the existing databases of declared SEPs include many declared patents that are in fact not essential. Therefore, while licensing and litigating over SEPs, there is always a considerable uncertainty over the quality of the licensor portfolio, which may include many non-essential or even invalid patents. With this in mind, in the report, we have included some proposals to improve transparency, in particular with respect to SDO's databases of declared SEPs and assessment of essentiality of standard essential patents. So with respect to the essentiality, with the objective of improving the transparency of essentiality determinations, in the report of the expert group, it has been first proposed that SEP holders have independent bodies, like, for example, patent offices as the European Patent Office, or alternatively supervised networks of certified law firms, to check the essentiality of their declared SEPs shortly after approval of the standard. Second, to keep the cost of essentiality checks at a reasonable level, preferably only one patent in a major market country per patent family should be checked combined with self-certifications for other members of that family. The use of AI search tools may also be considered to support these essentiality checks as a measure to further reduce cost. Third, Yes?
Sorry, Aleksandra, is there a process by which essential patents are deemed not essential? So they're essential, and then the standard changes or evolves, and there's a methodology in which, a previously essential patent becomes non-essential?
So there's no such a methodology as such, and for this moment it is really established in litigation whether a declared patent is essential or is not essential, for example, due to changes in the standards. So that's why one of the aims of the report was to propose some solutions aimed at facilitating verification of whether the patents are in fact essential or not.
And what are the particular issues arising in the IoT field? Is this just because there are so many more components and different numbers of patents required in these products, or is it just because it's new and developing? Is there a particular issue in the IoT, Internet of Things area?
Yes, you have correctly pointed this issue out because it is considered that in the IoT there will be many standards and many standard essential patents that would apply to different objects applied in the IoT sphere. So there will be many players, many verticals, and the licensing and valuations of standard essential patents that should be used in this technology would be still highly problematic. So the transparency in particular is needed with respect to development of the IoT technologies.
And we're really only at the start of the IoT, so maybe it's a good time to try to, sort it out now. Let's move on to another. Sorry, please go ahead, Aleksandra.
I would just say that this is the reason why the European Commission already started analysis on how to facilitate licensing and valuation of standard essential patent in the IoT sphere to keep European standardization competitive still in this field.
Right. To try to continue to lead the field, maybe worldwide, in how this will develop.
Exactly.
Let's move on to talk about FRAND a bit, fair, reasonable, and non-discriminatory licensing commitments, which these SEP holders have to put in place as part of being allowed into or to form part of the standard. What about the ND part, the non-discrimination? How do we? I know that the experts looked at this. What were the comments there in relation to non-discrimination and how we actually establish whether a license is or is not ND?
Yes, of course. So non-discrimination, the concept of non-discrimination is an important part of the SEP holder's commitment to license its SEP under FRAND terms and conditions. And in the report, we have agreed that this aspect cannot be seen independently from the effort side of the front commitment. This is because the presence or absence of discrimination must be assessed based on the totality of the terms and conditions of a license agreement, and not by comparing one isolated term in an agreement with its counterpart in another agreement. We have also noticed that it is generally agreed that the ND commitment does not require the SEP holder to offer the same terms and conditions to all licensees. In fact, a SEP holder should be allowed to respond to different market situations by offering different licensing terms. However, in the presence of similarly situated implementers, differences need to be objectively justified based on a holistic views of the relevant elements. This is because the non-discrimination commitment requires the licensor to treat similarly situated parties in a similar manner. In the EU treaty, a similar requirement follows from Article 102C, which prohibits dominant firms to engage in anti-competitive discrimination. What is more, analysis of the ND condition is in large part based on comparing license terms and conditions offered or granted to licensees that are similarly situated with those offered to a potential licensee. Therefore, also here some level of transparency with respect to existing licenses is required. However, as you may well know, non-disclosure obligations in license agreements may make it impossible for licensees and licensors to verify that the ND limb of front commitment is satisfied. To address this problem, in the report, we have also proposed the creation of a confidential repository of existing SEP licensing agreements, which could be used by courts, competition boards, public arbitration boards, or trusted persons. Finally, what is important, we have also proposed that European Commission proposed a methodology which could provide certain ranges as a sort of safe harbor within which the license is considered non-discriminatory by identifying key factors which may have an impact on this assessment. It is often unclear for the SEP holder and the SEP implementer which royalty rate, taking into consideration both external and internal factors, is considered non-discriminatory. Therefore, this methodology, which is in details described in annex to the report, aims at providing guidance on the ND prong, principally for the parties before and during negotiations, but also during litigation.
Aleksandra, you partially answered this question, but what is the current state of the law, or what's the dispute? What's the disagreement about, what makes a FRAN license non-discriminatory? Are there some courts saying that, a single term has to be identical, or is there disagreement about that?
What we see is that in majority the courts are comparing royalty rate, but what we consider important is that it's not only the royalty rate that should be taken into consideration while analyzing whether the licensing terms and conditions are not discriminatory, but all relevant licensing terms and conditions. What is more and is subject to disputes is whether given licenses are similarly situated or not. This is also difficult in practice to assess.
Right, and very difficult to do on a case-by-case basis through the courts.
Exactly.
A very recent, you referred to litigation. Here in the UK, there was a very recent Supreme Court judgment on Wired Planet, which looked at how you define FRAND. It looked at it as a single composite obligation and not three separate requirements, i.e. Not requiring fair and separately reasonable and separately non-discriminatory. Was that reviewed in the report, and what is your view on that judgment, which is obviously now the leading law, at least in the UK, because it came from the Supreme Court?
Yes, of course. So basically, the report is partially in line with this judgment in its statement that non-discrimination part of front commitment should not be read separately, but it should be read as a whole, so in comparison with fair and reasonable terms and conditions. But what I think is controversial in the Supreme Court judgment with respect to non-discrimination is that it is not entirely clear. It suggests that provided that the royalty rate is fair and reasonable, it will be automatically non-discriminatory as well. And the Supreme Court stated that non-discrimination only gives color to fair and reasonable. And this was not explicitly touched in the report, but I am of the opinion that if a rate is reasonable and fair, it does not automatically mean that it is non-discriminatory. We should conclude whole assessment also of other terms and conditions of this agreement to state whether license as a whole is compliance with front commitment, including its non-discriminatory aspect.
Yeah, I think we could probably talk about FRAND all day, but I know you were heavily involved as well in the report about another substantive topic, which you mentioned in your introduction, the level of licensing. So the issue of, and also it's important because here in the EU, or we're not in the EU, but in the EU, there's an important European Court judgment coming up in the Nokia Daimler case. So this is the issue concerning whether SEP holders should license at the end product and or the component level. Should they be required to license at one or more of those levels? And I think that there's a lot of tradition here. In some industries, it's traditionally at the end product level. In others, it's at the component level. I know this was looked at in detail. So what did the report talk about in this area?
Yes, you are completely correct that it is one of the most disputed questions in the context of SEP licensing currently. In the report, as the members of the expert group, we have decided not to take position as to what is the appropriate level where licensing should take place, as there may be no single answer to this question. Nevertheless, we have tried to resolve this issue by setting out 3 principles that could guide the licensing of SEPs in the value chain. First, the first principle is that licensing should take place at a single level in value chain for a particular licensed product. Licensing at one level rather than at multiple levels will substantially reduce transaction cost and risk of double dipping, as well as the risk of undercompensation for the licensor. Second, a uniform front royalty should be applied for a particular product, irrespectively of the level of licensing. Thus, the royalty for a license for a SEP portfolio that is fully implemented in the end product should be the same, whether it is licensed to an OEMs or to supplier in the latest product also fully implements that SEP portfolio. And finally, the front royalty is a cost element in the price of a component and should be passed on downstream. So if licensing is targeted at a level higher up in the value chain, to avoid situation where the supplier would have to absorb the entire cost from its profit margin, it should be possible for the supplier to increase the price of its product to account for an extra cost of the license fee. Thus, the related costs should be passed down in the value chain. For those principles to work in practice, some of the members of the expert group expressed their views that vertical coordination discussions may be needed in the relevant value chain to apply those principles in practice. But also, as you have mentioned, fortunately, the question of the level of licensing considered under the lenses of the EU competition law will be dealt by the Court of Justice of the European Union, as in November 2020, the Regional Court of Düsseldorf referred several questions to the European Court.
As you say, antitrust or competition law impacts this. That case is looking at where the SEP holder should license. And as you say, there could be issues with deciding on that first principle at a single level. You talked about there would be, it seems like there'd be some coordination going on if licensors are all discussing where to license. Shouldn't licensors just be able to decide for themselves? Why should the court or competition law impact that decision? Or is it just inefficient to do it that way?
As you have mentioned, it doesn't work in practice that licensors are deciding on their own where to grant a license, because there are also arguments in favor of the rule that under front commitment that is filed by the relevant patent holders to the standard setting organizations, actually patent holders are obliged to license their standard essential patents to all licensees that are requesting such a licenses. And I believe that those disputes currently result from the fact that traditionally licensing of standard essential patents in the cellular technology has been taken place at the end product level. While, for example, with this development of Internet of Things and in particular connected cars, the industry is used to the rule that those are in fact producers of components that are acquiring relevant patent rights, so that they are selling their products already cleared to the manufacturers of the cars themselves.
So different things going on in different industries.
Exactly.
Let's move on from the substance of the report and let's look a bit forward. As we said, this wasn't a European Commission report and it doesn't bind it or reflect its views, but it's going to be taken into account, no doubt. Or is there no doubt? Do you think the Commission will follow up on any of the 70 plus proposals, take some of them on board, or is it just going to be filed, despite the huge amount of work and expertise, it's just going to be filed on and won't impact much of what's going on from the Commission's point of view?
So now the Commission is organizing a series of publicly available webinars concerning standard essential patents in order to share some of the ideas developed also in the report of the expert group and to discuss with stakeholders potential improvements to the framework governing standard essential patents. Also, it has been stated in the European Commission IP Action Plan that I have already mentioned that the Commission will now facilitate industry-led initiatives to reduce frictions and litigation among players in specific sectors. And in parallel, the Commission will also consider reforms. In this IP Action Plan, the Commission already stated that, for instance, it will explore the creation of independent system of third-party essentiality checks in order to improve legal certainty and reducing litigation costs, in particular to address this lack of transparency problem. What I would also like to underline is that the expert group recommended that the Commission, should it decide to take further policy actions in the field of SEPs, to duly assess the impacts of any such proposed policy actions, notably as regards its possible effects on the future of standardization in the EU and in 5G and 6G development and implementation. So we will see what the future will bring.
Certainly a space to watch, and it'll be interesting to see what the dialogue looks like out of those webinars and what the EC decides to do with these recommendations, and honestly other jurisdictions as well, as I think the report is comprehensive and addresses things that all jurisdictions should be thinking about. So Aleksandra, thank you for all of this very substantive content. But before we let you go, we always like to ask our guests a few questions. The first is to tell us something interesting about yourself that we wouldn't know about you if we just knew you professionally.
When I was young in the primary school. I was professionally training swimming, and I was taking part in national competition. So
wow.
the first thing that you would not know. And the second thing is that I have a son, which is who is 3 years old. So it's really absorbing and we can say challenging to connect the role of mother and IP lawyer.
And certainly during COVID, having a 3-year-old running around is more challenging than it might otherwise be. What was your swimming stroke? Freestyle, backstroke, butterfly?
So freestyle, that was my preferred swimming. So.
And is your son swimming yet, or is he?
No, I wanted to take him to learn him how to swim, but unfortunately, because of this pandemic situation, I am not able to take him to the swimming pool. So
Yep.
I waited for the summer, maybe in the Baltic Sea in Poland we will try, but it's really cold also during the summer, so I don't.
Yeah. And Aleksandra, what advice do you have for younger lawyers who are looking to do what you do?
I would recommend them that if possible, they should try to spend some time during their studies or practice on a foreign university somewhere abroad. For example, in Europe, it has been possible within Erasmus program, and I was also benefiting of this program. I believe that it is important, as working as a lawyer requires also wider perspective on the relevant provisions, which have often international business perspective, as in case of SEPs. Moreover, it gives a unique occasion to make contacts and meet people from all over the world, which in the future can result not only in business opportunities, but also in long-lasting friendships.
Couldn't agree more. That's great advice for our listenership. So Aleksandra, I'm going to pivot now to our last segment, what we call the Curious Hat.
And now it's time for the Curious Hat!
So Aleksandra, I'm going to ask you to pick a number 1 through 25.
Maybe 5?
5. Okay. Are there any TV series that you are currently watching that you would recommend?
Recently, I have been watching a series on Netflix, Queen's Gambit. It was about chess, and I have really enjoyed it. I think that I have watched it during 2 nights, so it was really engaging.
So you finished the entire series in 2 nights?
Yes.
I just started it, but it's with the hour-long episode, so I'm impressed that you did that in 2 nights. I can't wait to get to the end of it.
I highly recommend it.
Very good. Well, Aleksandra, thank you again for joining us today, and to our listenership, thank you for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust.